Hello to my Law and Society class. This is week 3 of our summer session 2020 in Law and Society. I want to spend the next 20 or so minutes talking a little bit about the issue we are just finishing and the new issue we will be starting. So first, let's talk about physician aid in dying. Many of you have sent in your assignment that you were given, and many of you will be sending it in by tomorrow night, no later than 6:30. That's Tuesday, June 2nd. I hope some of the things that you have gotten from this particular issue is the ability to talk to people about this issue, the people that I had you interview, and discuss it, including the words themselves. Words have meaning, and we have seen since the title of this issue has been changed from physician-assisted suicide and all of those negative connotations, both legally, morally, religiously, and from a societal view, to physician aid in dying, and the fact that it is only allowed in those states and the District of Columbia that do allow it in cases where someone is terminally ill, where someone has been determined by the medical experts that they will probably succumb to this illness with their own death within 6 months. I'm reading some of the ones you've sent in. I look forward to getting all of the others and seeing what your discussions have shown you, because although we're not in class with these discussions, the assignments, I hope, will help you stretch and get a feel for what discussing these issues from a legal and societal point will be. Okay, so that's physician aid in dying. I look forward to reading the rest of the assignments that you're sending in. This week we are going to be tackling another issue, a very important issue that seems to be in the forefront, especially when we talk about new nominees to the U.S. Supreme Court, and it stems from the 1973 U.S. Supreme Court decision of Roe v. Wade. Roe v. Wade, decided by the court in 1973, is referred to as the abortion case, and that decision by the U.S. Supreme Court in 1973 made the right to choose whether or not a woman wishes to terminate a pregnancy a constitutionally protected right. Those of you who have taken constitutional law, or those of you who read through my notes and have listened to some of the lectures that I have done, know that one of the things I often say is that no right at all, no constitutional right, no law is absolute. And what we mean when we say no law is absolute, no right or power is absolute, that means that every right, every power that we have, every law, everything in the Constitution, they all have limits. So when we say that, yes, the woman's right to choose whether or not to terminate a pregnancy is a constitutional right, it does not mean that a pregnant woman has the right to terminate a pregnancy at any time during her pregnancy. So I want to discuss that for the next few minutes to give you some kind of foundation on Roe v. Wade, because a lot of people, you hear a lot of things in the news, you read a lot of articles, people are very passionate on both sides of this issue, but the reality is that even in 1973, when the U.S. Supreme Court decided this case, they were extremely specific. And on a test where I ask you about this, I always ask about what that 1973 decision said about a woman's right to choose. So let me explain that to you here. A human full-term pregnancy is 40 weeks. And so the U.S. Supreme Court in 1973 divided a pregnancy into what we call 3 trimesters. They evenly divided the 40 weeks into 3 13-and-a-half-week trimesters. And there are rules for the first trimester, different rules for the second trimester, and then different rules for the third trimester. I also want to tell you that throughout our history, whenever we talk about abortion, the key word that is both now a medical and a legal word that is used in this issue is viability. So we're going to define viability. Viability is that point in a human pregnancy where medical authority believe if this child was born, if this fetus was born, that child could live outside the mother's body, okay? Because with Roe v. Wade and today with this issue, everything is focused on viability. At what point is it that the medical authority say, and of course it's not a guarantee, it's just their opinion as we evolve with more technology and a better ability to keep a woman's child who has delivered earlier than the 40 weeks alive. In 1973, when Roe v. Wade was decided, viability was thought to be in the medical community at 32 weeks. That's 32 out of 40 weeks was considered viability. That probably, in most cases, if a woman went into labor and delivered her child, that child would probably be able to survive from 32 weeks on. That was 1973. We've made a lot of progress in the ability to treat and keep a preterm pregnancy and the child alive. Today, 2020, that 32-week time period has come way back, and depending on which hospital and what doctors, but basically it is back all the way to 24 weeks, with the belief that in most cases, not all, a woman who goes into early labor and she is at least 24 weeks along in her 40-week pregnancy, if she delivers, there's a good chance that that child is viable, that child will be able to survive outside her body. Now, there are some rare cases even before 24 weeks, but 24 weeks is pretty much the accepted number right now in 2020. Who knows in the future what it will be? In the future, we may see where, there is a way much earlier that a fetus could be born and survive outside the mother's body. So what happens is we're going to look at the Roe v. Wade decision and what they said using 32 weeks as viability, and we're going to talk about what changes, how they've adjusted, because Roe v. Wade is still good law, but the weeks, the trimester division has changed somewhat. So let's talk about this. The first thing I want to talk about is under Roe v. Wade, the trimester approach. So the trimester breakdown. In the first trimester under Roe v. Wade, which would be from the 1st to the 13th week, or thereabouts, 13th and a third week of a woman's pregnancy, we say that pregnant woman has the right, the constitutional right to abortion on demand, meaning no one can stop her. If she wants to terminate that pregnancy, she has an absolute right in that first trimester to do so. In the second trimester under Roe v. Wade, which would be from about 13 and a third weeks to about 26 and 2/3 weeks, we are talking about the decision must be made by a woman and her doctor. So it is, again, the woman and her doctor conferencing, deciding, and making that decision together. The farther a woman is along in her pregnancy, the more of a risk it is to the mother's health and life to go through this process. Okay, again, remember, we're talking about Roe v. Wade, 1973. The third trimester, which goes from about 26 2/3 weeks till 40 weeks, at that point, once you reached viability, which was 32 weeks, a woman no longer could get an abortion, okay? Viability is that cutoff. Now, that doesn't mean, what might happen, let's say a woman who was 30 weeks or 32 weeks or something pregnant and was in a severe car accident and it became, a life for a life, it's possible that that child might not survive outside the mother's body, or the mother might not survive. But we're talking about Roe v. Wade under normal circumstances, breaking it into 3 trimesters. Okay, so why has that evolved and changed somewhat since 1973? Well, here's why. Because in 2020, that viability date of 32 weeks is now brought back to 24. So now what happens is that we have adjusted these sort of trimesters into different rules. We still, in the first trimester, a woman from week 1 till about 13 and a half weeks has an absolute right to make the decision on her own whether or not she wants to terminate her pregnancy. However, now what happens is at the end of that second trimester, we are hitting viability. It's safe to say that once we get to viability, a woman's right to have an abortion is either forbidden, banned, or it is only in the case of the mother's life versus the child. And so instead of having 3 trimesters now, we basically have the same first trimester, and then the farther along you get in the second, the closer you get to a point where a woman will no longer have that right to choose going forward. And that is simply because of medical and science technology becoming so improved. We may see a day sometime in the future where at 15 weeks or 13 weeks in a pregnancy, perhaps they will be able to advance to the point where they'll say viability could be then. But right now, in 2020, it is about 24 weeks. Okay, so now we've gone over Roe v. Wade, we've gone over the original trimesters, which I usually ask on an exam. We've talked about viability in 1973 versus viability in 2020 and the effect that has had on the part of Roe v. Wade that talks about those trimesters, keeping in mind viability at all times. So there have been adjustments. I want to talk about the term precedent, stare decisis, and rule of law, which we have discussed before. But Roe v. Wade, decided by the U.S. Supreme Court, means that that decision must be followed and respected by every state and every court in this nation. And so precedent means that in every one of the 50 states, a woman has a right to choose under the terms of Roe v. Wade, updated to 2020. When do we most hear about Roe v. Wade? When there is a vacancy on the United States Supreme Court, as there has been a few. There's been 2 under President Trump, and there were 2 or 3 under President Obama. And so what happens is when there is a vacancy, either because a Supreme Court Justice of the United States has retired, has died, what happens is whoever is the president at the time gets to nominate a person to the U.S. Supreme Court. That person who's nominated then has hearings before the United States Senate. And the United States Senate then must confirm that person. And if they confirm that person, if they vote in favor of that person then becomes a United States Supreme Court justice. Now, what happens is precedent, cases that have already been decided by the United States Supreme Court, when other cases come before the courts of the United States with those same or similar issues, they will follow that. That's what stare decisis means, to stand by a decision that has come before, precedent. And the rule of law means that whatever reasoning the court gave in its decision of Roe v. Wade, they will follow that in other cases like Roe v. Wade that come before the court in the future. Now, one of the terms you're going to see in our issue this week, and by the way, our issue is found in the book. It is issue 2.1, and the question it presents is it constitutional to require physicians who perform abortions to have admitting privileges at a nearby hospital? Now, you're going to see the term, and it'll be used here in this issue, but it'll also be used in other issues we discuss. The term is undue burden. When we talk about abortion, when we talk about voting rights, the term undue burden is going to be key, and you are going to have to understand it and be able to write about it on an exam. Think about those words, undue, D-U-E meaning owed. So undue burden, a responsibility. When the U.S. Supreme Court decides we have a constitutional right to something with limits, whether it's abortion or whether it's voting, the right as an adult to register and vote in elections, any attempt by the government, whether it is the federal government, state, or local, to put a burden on that right to try and prevent people from exercising their constitutional rights, we refer to that as an undue burden. It's like an unfair way to keep someone from exercising their constitutional rights, okay? And so in this issue that we're going to read, there were two parts to this issue, okay? It's about a state passing two laws. One law says that any licensed physician in their state who performs abortions must have admitting privileges. Now, admitting privileges are when a doctor is on staff, so they're permitted to put their patients in, to treat their patients if something goes wrong at a nearby hospital. So it puts an undue burden that if a doctor does not have admitting privileges and cannot get them, because hospitals just don't give them out, they have certain limits, what will happen is that that doctor can no longer legally perform abortions because they don't have admitting privileges to the nearby hospital. That puts an undue burden on a woman to get an abortion legally from a doctor if that doctor doesn't have admitting privileges. The other part of this, the second law that was also passed here, said that any clinic that performs abortions must be set up like a surgical center, basically like a hospital. So that means for decades in this country, for decades and decades, these clinics are suited, and there's never been a complaint that they're not suited to perform these procedures, and yet the state decided, let's pass this law. Why? Because it is millions of dollars to set up a clinic like a hospital, to make it like a hospital. Therefore, doctors who do abortions will not be able to comply with that law, and there will be less and less doctors in less and less places that will make abortions legally safe and available to women. It places an undue burden. The point of these laws, and when you read the article in the book, you'll see there is no medical evidence to support that these laws make it safer for a woman to get an abortion. But these laws were created to try and limit a woman's access to terminating her pregnancy. They couldn't do it by trying to find Roe v. Wade unconstitutional, so they try to do it by limiting the doctors, having less and less doctors who can afford to actually follow this law. Well, guess what? These laws were struck down as an undue burden, unfair, and therefore illegal, and they no longer will exist. Okay, so there is also a dissenting opinion here, and the dissenting opinion is not the majority opinion, it's not the law, but it is a or several justices on the Supreme Court who don't agree with the majority. Remember, appellate courts, and the U.S. Supreme Court is the highest appellate court in the land, appellate courts rule by majority vote. So you want to also take a look at the dissenting opinion from the justice who did not agree. Okay, so that gives you sort of an overview of the most important sort of things I want you to be aware of when you read this particular issue this week, and we'll address it. Okay, so we're going to end here. I will be sending you the link to this lecture and also your assignments for this week on Tuesday and Thursday. I hope you are enjoying the weather that we've been having. It's a little cool, but at least it's been sunny. And I hope you are all staying healthy and safe for yourselves and your families. Okay, I will post another video next week. Have a great week. See you then.